where the wrongdoer may actually use a mark totally different from the famous trademark on the product, but the company name will also appear too and quite prominently. There is a need for proper coordination between the offices of the company registrar and the trademark registrar in respect of foreign trademarks to prevent the possible misuse of the hard-earned goodwill. Now next is the similar marks and the similar goods. The registration by a third party of a mark which is identical with or similar to a registered mark in respect of the same or similar mark, similar goods is not permitted in the present trademark law. As we all know, goods and services they are divided into 42 classes, and according to the present practice of the trademark office, if goods or services fall within the same class, office will raise objection treating that the goods are similar goods or the services. Now, many trademark registrations have been registered in respect of the class heading of a heading, and the goods instead of precise items on the goods or services in that class. This has been a common practice for the past many years as a way to seek protection for the whole class of goods. By registering the goods or services for the whole class, the registrant of the mark is blocking another person from getting registration for a particular goods or service. His only purpose is to block another person from getting a similar mark registered in another person's name. The only provision left to a potential applicant is to file a petition for rectification, which is, as we all know, very time-consuming process on the ground of non-use. To avoid this, the blocking of the trademark registration by a potential user, India could follow the trademark procedure in the United States in respect of an intent to use application. There, the US Trademark Office will allow the mark for registration instead of granting the registration. Then the registration will be granted only after proving the use of the mark in commerce within 3 years of allowing the trademark. Our trademark concept of well-known trademark. This was introduced into the Act by the amendment and in section 2(G). The Act also states as a principle that in determining whether the mark is a well-known mark, the registrar shall take into account any circumstances from which it may be inferred that the mark is well-known, including like the degree of knowledge or recognition of the mark in the relevant section of the public, then including knowledge in India obtained as a result of promotion of the mark, the duration, extent and geographical area of the use of the mark, or any promotion of the mark including advertising, publicity or the record of successful enforcement rights in the marks. Under the Act, the registrar shall not require use, registration or pendency of an application in India for determining whether a mark is a well-known. It is for the registrar, the courts, the Intellectual Property Appellate Board to decide whether a mark is well-known or not. It is easier for proprietors of well-known marks to prevent others from registering their trademark. However, as said, there is no register of well-known trademarks. Creation of such register is highly desirable to avoid any confusion and bring clarity with regard to the well-known marks. Another area is the domain name. As a species of intellectual property created by the digital age, domain names are most widely known and discussed. They are easy to remember and use, and it is precisely for this reason that they have been assumed a key role in e-commerce. Trademarks and domain names bear so much similarity in their functions, and yet the two are irreconcilable in terms of their names. Unlike trademarks, domain names do not respect national boundaries. When domain names are protected as trademarks, one of the major problems in this area is cyber squatting. A mere registration obtained by a cyber squatter for a domain name which infringes a given trademark without any steps taken to host a website corresponding to the impugned domain name raises issues of violation and is actionable. Available remedies include the transfer or cancellation of the registration. However, the use by such cyber squatter of the impugned domain name as the address for an active website on the internet brings into play issues of multinational jurisdiction. In other words, where to sue the offending domain name registrant and how to enforce any judgment obtained from an Indian court on the basis of personal jurisdiction against registrants based outside India. Moreover, as of now, the domain name registry and the trademark registry work independently world over, and domain names are allotted mostly on the first come, first served basis. And international coordination amongst various trademark registries and domain name registry will hopefully serve to minimize the cyber squatting and domain name disputes. Another important issue is the sale of counterfeits, fakes and replicas through internet sites, including famous auction sites. The virtual world is proving to be a better hiding place for dealers in such goods. Besides profiting from such sales, website owners are claiming immunity from any illegal acts done by the counterfeiters on and through their websites. Now, another area is the non-traditional trademark. The 1999 Act has been very important in the development of trademark law and practice in India. It provides for registration of traditional and non-traditional trademarks such as shapes, colors, smell, taste, sound, etc., as long as they can be graphically represented. If characterization of a product or its representation is unique, it would appeal to people's perception and sense in a very significant manner. The advent of internet and electronic commerce has also increased the range of signs that business would like to use as a registered mark. For example, motion and sound marks would capture the attention of internet users much more efficiently than a traditional trademark, which in turn have catapulted their popularity in today's commercial world. There are several problems which makes the registration of non-conventional marks as trademarks. The first problem is the distinctiveness criterion itself. Though certain non-conventional trademarks like shape and color can be identified by consumers, for others like smell and taste marks, perceptions about the mark may vary, giving rise to confusion among the consumers. The second problem is graphical representability of the mark to be registered, especially in cases of smell and sound marks. Graphical representation of these marks is more of a practical than a legal problem. Coupled with distinctiveness, it may pose a serious obstacle in the way of registering non-conventional trademarks. The protection of trademarks is the law's recognition of the psychological function of symbol. New forms of such symbols or marks have greater psychological impact on consumers and hence more commercial significance and should be provided similar protection as other traditional forms of marks. Difficulty in registering such marks as trademarks on paper should not act as a deterrent to their use, and new methods of identifying and classifying such marks should be evolved to afford protection to the users of such non-conventional trademarks, and newer ones that may come. The Indian Trademark Registry has to include in its manual detailed guidelines concerning the examination of the unconventional trademarks. The Indian legal framework on trademarks is in tune with trademark laws all around the world, and there is no reason to believe that jurisprudence on non-traditional trademarks will not develop. In conclusion, I would like to add that despite these vital issues, trademarks are better protected in India than they are in some developed countries of the world. We recognize trans-border reputation. Our courts tolerate non-use by the plaintiff for a considerable period of time. Our courts have passed audits on spamming, hyperlinking, meta-tagging and so on, even without any specific legislation. Consequently, I regard the Indian trademark law as a strong one, and I am extremely optimistic of its becoming even stronger in the future. Thank you.
Thank you, Mr. Jacob. You have rightly said that although there is may not be direct law on some of these subjects, yet the Indian courts are enforcing them as far as possible. So far domain name is concerned, there was no specific law protecting the domain name, but still in around about 2000, the Delhi High Court has given protection and enforced the rights of domain name. So far Yahoo is concerned, a case was filed in the Delhi High Court and an injunction was issued immediately under the law of trademark, because domain name is also could be a trademark, and therefore taking advantage and cue from the trademark, an injunction was issued. So therefore, even when there is no law protecting a particular subject, like we are importing the idea from the Trademark Act or Copyright Act and then trying to enforce that. So therefore, as you said, I would say I would not agree with you, Mr. Jacob, when you say that enforcement is difficult in India. It is not so. The courts are trying their level best to enforce the intellectual property rights are concerned. They are taking lot of steps as of today. They are providing, as I said, training. They are updating the laws. They are updating the awareness so far the judges are concerned. They are trying to bring in exclusive courts. Although we decide the cases in general courts in India, but in some of the high courts, exclusive courts are being used for the purpose of deciding only IPR matters in the subordinate courts. Now, let me also tell you that 70% of the cases that are instituted in the IPR sector are instituted only in Delhi. There are 70% cases in Delhi pending, and they are being tried. I had the advantage of being associated with the Delhi High Court for a number of years, and I know for a fact that efforts are being taken to dispose of these matters. Now, so far foreign companies are concerned, we have recognized, you have rightly said, Mr. Jacob, that we have recognized the trans-border reputation. Even the multinational company not being physically present with their product in India, and it's not being registered in India, yet we are given protection. Like, for example, we have given protection to Whirlpool without their being physically present in the country. The Supreme Court has upheld that decision of the Delhi High Court. And then we have also given such protection to Bench, that motor car. Then Colgate-Palmolive, that point of time Colgate-Palmolive was not present. We have given that protection to them. So therefore, we are giving protection to these MNCs. There is no difference being made between domestic companies or the companies of these multinational companies. So I believe. And then we have in our law both civil and criminal remedies open. We have civil remedies, as I said,